This video goes over what Court Assistance Office forms are and how you can use them to represent yourself. The Court Assistance Office was designed through the Supreme Court of Idaho in an effort to make the courts more accessible to people without having to hire an attorney. By using these forms, you will be representing yourself in court. Sometimes cases are complicated, and instructions in the forms are not a substitute for legal advice. The laws and court rules are complex, and following these instructions will not guarantee you a favorable result. You may need to consult with an attorney in order to move forward with your case. Most Court Assistance Office case types can be divided up and explained in 3 easy steps. Step 1 is filing a petition. Step 2 is serving the other party with a copy of what you filed. And then step 3 is waiting 21 days to give the other party a chance to contest or respond if they want to. And then afterwards, if they haven't responded, you can submit paperwork to finalize for what we call a default judgment. This can be done 21 days after they've been served. So step 1 is filing, step 2 is serving, and step 3 is waiting 21 days and then finalizing. So let's take a little bit closer look at what we do for step 1. First, you're going to want to get your forms. All Court Assistance Office forms are available online for free, or you can get them by email from your local court assistance officer, or you can come into the courthouse and purchase them for a fee. Once you get your forms, you're going to fill them out. Make sure you use black pen, and then you can have a court assistance officer review them for you. Then you're going to want to make copies of your forms and then pay your filing fee and file them at your local courthouse. When you go to file your Court Assistance Office forms, if you are filing a case that has to do with child custody or child support, you are most likely going to be ordered to attend a Focus on Children class. This is a co-parenting class that's uniform throughout the state of Idaho. No matter what county you file in, you're probably going to be ordered to attend this class. If you have children between the ages of 6 and 17, they will probably be ordered to attend a children's class at the same time. The class is $35 per party, and you will want to ask any specific questions to your local family court manager. After that order is issued, you're going to see some joint prohibitive orders issued. The first one would be a joint prohibitive order on the children, and the next one would have to do with divorce only, a joint prohibitive order on property. If you have any questions about these, please read them. They're very descriptive and explanatory. It's nothing you need to panic about. They're mandatory orders ordered for any case type that has to do with either child custody or divorce. And you'll just want to be familiar with them and know what's expected of you so you can move forward with your case. Once all these orders have been issued by the clerk, your paperwork is going to be divided up into 3 piles. First, you'll have a pile of all the paperwork for the judge, and then you'll have a pile of all the paperwork for you, and then a pile of all the copies of the paperwork for the other party to be served with. When you are done at that counter, you've just transitioned from step 1, filing, to step 2. Now it's your responsibility to make sure the other party is served with their pile of copies. The Court Assistance Office has 2 forms that you can use to verify to the court that the other party has been properly served. The first one is called an acknowledgement of service. This works really well when you're working with the other party. They would sign in front of a notary acknowledging that they received the forms on a specific day. This also works really well if the other party is out of town. This can be signed by any notary in any state. So if this form is convenient for you, take advantage of it. If you are not working with the other party and it would be more convenient to have somebody else serve them, you can use the affidavit of service. This would be used by having somebody 18 or older who is not a party to the case, an uninterested party, serve the other party with a copy of the paperwork and then sign the affidavit certifying that the other party was properly served. This does not need to be notarized. You also have the option of hiring your local sheriff to serve the paperwork for a fee, or a lot of times there are professional process servers that will serve your paperwork for a fee. If you do not know where the other party is, there is also an option for you to complete service by publication. This would be done by receiving first permission through the courts to accomplish service by publishing a notice in the newspaper. This is going to take more time and cost more money, but if this is the only way you can move forward with your case, it's absolutely available to you. Once we know what day the other party was served, your 21-day waiting period begins the day after. During this time, you can be preparing all your Step 3 paperwork for a default judgment. Please fill out the paperwork and have it reviewed by your local court assistance officer, and prepare to submit the paperwork to get a default judgment if the other party has not responded within the 21 days. Now let's talk for just a second about what happens if the other party does file a response in your case. The first thing that you should do is don't get upset and do not panic. It is absolutely the other party's right to file a response in a case, just like it is absolutely your right to file a petition. Instead, what you need to do is carefully read the document, because it is either going to be a response or a response and counterclaim. And it's important for you to know exactly what it is. If you need help, you can contact your local court assistance officer, and they can help you identify what type of response was filed. So if it's just a response, you need to read it over and identify what the other party agreed with and what they didn't agree with. If it's a response and counterclaim, then you need to respond to the counterclaim within 21 days. Now, there's always two things that are going to happen if somebody files a response in your case. First, if your case involves child custody and child support, you are both going to be required to submit mandatory child support disclosures to each other. This is a form that discloses your income for the last 2 years and year to date to each other. Contact your local court assistance office and they can provide these forms for you. They are also available online. So make sure you get those started. They're not hard to fill out, but they are important to complete. Next, your case is going to be set for a scheduling conference in front of the judge. This is not the trial. This is where they will schedule the trial. It's important for you to be there so that your case can move forward and you can possibly be ordered to mediation in your case. If you have any questions about what has been filed in your case, please contact the local court assistance officer as soon as possible to obtain forms and detailed instructions explaining the next steps involved in your case.